Olá, pessoal, bom dia a todos. Eu agradeço a presença de vocês aqui hoje no nosso webinar. Acho que nós já podemos começar. Nós hoje falaremos sobre o Sistema Europeu Unificado de Patentes, que entrará em vigor no dia 1º de junho próximo. E no formato da apresentação, o nosso palestrante vai comentar um pouquinho como usá-lo de uma forma estratégica, que acho que é o que todo mundo gostaria de entender. Então, para falar desse assunto tão interessante, nós convidamos o Wieser. Vou apresentá-lo rapidamente em inglês, e então nós vamos iniciar com o tema de hoje. Hi, Michael. Thank you for being with us today to talk about this new patent protection in Europe. Michael is a patent attorney and a partner at an IP law firm called BRANDL from Germany. He's German, but half of his family is Brazilian, so he visits Brazil a lot, and I bet he will be soon fluent in Portuguese. Well, I will not take much time in this introduction because the subject is full of details, and I believe you would like to have a time to make questions and clarify doubts at the end of the presentation. So you can use the chat to make your questions, and Michael will answer at the end of the presentation. Okay, so Michael, thank you again, and the floor is yours.
Obrigado, Gabriela. Bom dia a todos. Eu falo português pouco, mas a apresentação eu vou apresentar em inglês, porque se eu falasse em português, demoraria tanto. So eu vou trocar para inglês agora. Okay. So thank you very much for this invitation. I'm very happy to give you a little bit insight of what happens now in Europe. Eu vou share my screen. And here we go. So I hope you can see everything. So the topic of today is the European Unified Patent System, and what are recommendations. So how can you use it strategically? I give you a brief overview of what I will talk about today. So I want to give you briefly some background information. So how the present system works right now. So how do you get a European patent right now, and what will change in the future? Then a little bit about the ratification process, because it took so much time to enter into force, and now it will enter into force very soon. I give you some outlines about what is the unitary patent and what is the unified patent court. Then you have probably heard about this topic opt-out. So what is it, and should you make use of it? I think we come later to that. And then I will also tell you what are some to-dos right now, or what you should consider when you file an application, or when you are just before the grant of a European patent, and also give you some insights regarding personal insight. Also, what are the pros and cons of these new systems, and then I will be happy to answer your questions at the end of the presentation. So here you see on the left side, blue are the European Union countries, and if you file a union trademark, then you get automatically protection for these 27 member states. So as you probably know, UK is no longer part of the European Union, so there are now 27 member states of the European Union. So for trademarks and for designs, you have this option to file a single application and you get protection in all these blue countries. The European patent system is quite different. So you have just a centralized granting process, one office which grants a European patent. For meanwhile, 39 member states, they are all indicated in red color. And these are much more countries than the European Union. For example, UK is still in the EPC, Switzerland, Turkey, Norway, also though those countries are not part of the European Union, but you can get a European patent for such countries. So here you just see we have a single examination proceedings before the EPO, and at the end you get a grant of a European patent. But in contrast to trademarks and designs, you will not have one single IP right valid in all countries. So after the grant, you have to validate your European patent. So all the national countries just acknowledge the result of the examination of the European Patent Office, but you have to validate country by country, and then you get a bundle of national patents. And when you want to enforce it, you have to go to the national court. So you have to go to the national court in Germany, you have to go to the national court in France, in UK, and so on. So there's no single court right now where you can enforce your patent for all such countries. This is also shown here that all this thing we have indicated. These are all kind of here like courts, national courts, and due to the national court system, we have differences in the procedural rules. We have different language of the proceedings. We have different case law, and even for the same case, so you have one is a patent owner, one is a infringer. It can happen that you get damages in Germany, but such damages will be denied in, for example, France. Although there's the same infringing product and there's the same patent, but the courts may decide differently. And this is something what was always criticized in the past. And therefore, what was the idea? To create something which is less expensive, simpler, and more efficient. And such objects should be achieved by two measures. The one is to create a unitary patent in the European Union, and also to create a unified patent court system in the European Union. There have been some regulations in the past agreed on, and you can see the dates, 2012, so it's more than 10 years ago, and still it is not in force. And it took some time to get everything started. So what is the basic idea behind the unitary patent? So for such countries like UK, Switzerland, which are not non-European Union members, nothing changes. So you still have to validate a European patent in those countries which are not part of the European Union. Unfortunately, up to now, not all European Union countries have ratified or even signed this new agreements. So right now we have on start just 17 countries. So Spain, Croatia, Poland, they have already said, no, we will definitely not join the system. So they will also stay out. So the only thing what will happen is that you get the option to get a kind of single IP right for 17 countries right now. So they may get more, but at the present it will be 17 countries when it starts. So you can then, instead of validating the European patent country by country, so in Germany, in France, in Italy, you just say, oh, I want to have a unitary patent for those countries, and then you get one IP, right? And sorry for that noise here. And then we have a unified patent court system, which is also a single court which can decide on such a unitary patent. So the unified patent court will look like that. So we have a first instance with local divisions, regional divisions, and central divisions all over Europe. And then we have a second instance, a court of appeal, which is a second instance, which will be a single court in Luxembourg. And with respect to some general legal matters, we will have the C as the Court of Justice of the European Union. So this will be the highest instance. The highest instance here in Europe. So about the ratification process, I said, so when does it come into force? It will come into force, and that was agreed on the 13th ratification. So from all of the European Union members, when 13 countries ratify this system, it will come into force 4 months later. But those 13 countries had to include those countries with the highest number of European patents in 2012. And that was, at that time, it was Germany, France, and UK. Due to Brexit, UK is no longer part of the system. And then Italy, which was in 4th position, had become a mandatory member of this system. So France had already ratified, Italy had already ratified, many other countries have already ratified the system. So why did it take so long to come in force? We have 2 constitutional complaints in Germany. One was in 2017 and one was in 2020. And it was said that both constitutional complaints were basically corrected, or it was dismissed because so it was just delayed a little bit. But at the end, these 2 issues was not crucial for why it became or why it entered into force so late, because you can imagine, if you establish a new court system with new court buildings, with new judges and so on, and new software, it takes some time to become to put everything into operation. And once the UPC has now signalized that they are ready to go, Germany, which was a mandatory member of the system, or is a mandatory, it actually then ratified now this agreement, so that it becomes comes into force 3 months later. So they ratified in February 17, so only 3 weeks ago, and it will enter in June 1st, 2023. So the ratification process, you can see here, when was it ratified by each country. And here on the right, you can see what are the countries which will be in. And it will be Austria, Belgium, Bulgaria, Denmark, Estonia, Finland, France, Germany, Italy, Latvia, Lithuania, Luxembourg, Malta, Netherlands, Portugal, Slovenia, and Sweden. And so these are the 17 countries which are now in. 7 countries signed this contract, but they have not ratified it. These are Cyprus, Czech Republic, Greece, Hungary, Ireland, Romania, and Slovakia. Out are Spain, Poland, and Croatia. So they have said that they are not part of the system, but they said they will accede to that system. Well, they may accede to the system, but right now they don't want to. And non-European Union states, they are out of the system. Okay. So the UPC is open to accession by any of the European member states of the European Union. They are on total, they would be 27. They are not, it is not possible for UK to join because UK is no longer part of the European Union. Spain, Poland, and Croatia have not signed this agreement, and 17 countries have ratified the UPC so far. So here you see 3 maps. On the left side, you see the EPC member states. There are 39. 24 have signed the UPC agreement. And on the right side, you see these are the countries which are now, from June 1st, part of this new system. So we said a lot about the unitary patent. So what does it actually mean? A unitary patent is a European patent with unitary effect, which means that a European patent that is granted by the EPO under the rules of procedure of the EPC, to which after grant, a unitary effect is attributed for the territory of the participating member state at its proprietor's request. So there will be no new system. It will be based on the present examination proceedings and also to the EPC rules and articles. So it will not change anything up to grant. So as I have already shown this slide some time before, so we have this new option to file a request for unitary effect in those 17 countries instead of validating also in such 17 countries, country by country. And then we have the unitary patent and unitary court thing. So here again, illustrated a little bit differently. So up to the grant, nothing changes. So when you file a European patent right now, you don't have to request a unitary patent at the time of filing. So you just file a European patent, and then at the end, once the European patent is granted, then you can decide whether you want to go the old way, the traditional way, to validate the European patent country by country. So this option is open for all 39 member states. And alternatively, but this option is only available for these 17 UPC member states, you can file a request for unitary effect, and then you get a unitary patent for those 17 countries. If you want to have patent protection in United Kingdom, you still have to go the classical way. So you can combine both. If you want to have patent protection in Italy, France, Germany, and UK, you can decide either to validate the patent in these 4 countries, country by country, or you can make a package for France, Germany, and Italy, and additional countries by filing a request for unitary effect. And for UK, you only validate it on a national level for UK via the classical way. So what do you have to do? As we had already said, so first we have to have a grant of the patent, and then you must file a request for unitary effect with the EPO. There are no official fees for that, and it has to be, this request has to be made in the language of the proceedings, and it has to be made no later than 1 month after the publication of the grant of the patent. And in addition, and this is something which is new, or this is different to the classical validation way, together with this request for unitary effect, you have to provide a full translation of the patent specification. As you know, when you just before you get an European patent granted, you have to translate the claims into the two other official languages of the EPO. For example, if the specification was in English, then you have to provide the translation of the claims into French and German, and then you get a European patent granted. And then, in addition, you need to provide a full translation for the specification and the drawings. And depending on what was the language of the proceedings, so if it was French or German, then you need a full translation of the description and the drawings. And if the language of the patent specification was English, then it has to be translated in any other language. And this has to be done for a transitional period of 6 years. And this transitional period is to be used that, for example, Google Translate or so is trained with these translations for the other languages. So the idea is after these 6 years, you will no longer need a translation for the patent specification, and all the countries can just rely on the automatic machine translation provided by Google on the EPO website. So you have 6 years, you have to do that, and this are some extra costs in comparison to some other to the traditional way, depending on the states you want to validate it. So here just indicated this is the so-called decision to grant communication, and in the lower part there's mentioned when it will be published in the European Patent Bulletin. For example, here in this case it was February 22nd, 2013. So 1 month later, you have to file, until that, you have to file such a request for unitary effect and provide the translation. So it's recommendable to think a little bit earlier about whether you want to have a unitary effect or not, possibly already when you receive the communication pursuant to 7013 communication, which is the preliminary allowance of a European patent. Before you provide the translations of the claims, then you have enough time to also provide a full translation of the patent specification. Okay. So what will we have in the future? We will have in Europe, you have lots of options now. You still can file patents or utility model if it's available in some countries. You can still file a patent or a utility model on a national level, just a national EP, German application, a national French application, and so on. You can have a classical European patent, which is then validated country by country. You may have a unitary patent for these 17 countries I mentioned before, and this will probably be the most common thing, that you have a combination of a classical European patent and a unitary patent. For example, you cover France, Germany, and Italy via the unitary patent, and UK via the classical EP patent. And the unitary patent covers the territories of the participating member states in which the UPC has taken effect at the date of the registration of the unitary effect. So right now we have 17 states. So if you file such a request for unitary effect, then it will be those 17 states. If Ireland, which is about to ratify the system, if Ireland ratifies it only in October, and you have already requested such an effect now in June, Ireland will not be part of the unitary patent. So it will not be automatically extended to all the territories which join later this system. And for this reason, we will have unitary patents of different generations. So if somebody has filed such a request for unitary patent in 2023, as of this year, this will cover 17 countries. And next year, it will possibly cover then 18 or 19 countries. And 2 more years later, it might be 23 countries. So, and for the entire lifetime, it will be frozen, this status. And so before, it will all be available from the unitary patent registry, and you can see where each unitary patent is valid. So, as you probably know, is when you validate a European patent in several countries, they have some translation requirements. So you need to provide an Italian translation when you want to validate it in Italy. You need to provide some additional translations of the claims when you go to Sweden, to Portugal, and so on. When you, as I said before, when you file such a request for unitary effect, then you will have to translate the claims, the description, and the drawings once. So there will be one full translation required, depending what I said before. If it's in English, then you have to in any language. If it's in French or German, then you in any other official language of the European Union. So when you right now, if you want to validate a European patent only in UK, France, and Germany, and this is the most common validation states. So most of the patents, they are only validated in those countries. As you probably know that Germany, France, UK, they are part of the London Agreement, and those countries being a part of the London Agreement, they said we no longer need a translation of the patent specification. So therefore, there will be no translation if you validate it in the old way, if in UK, France, and Germany, whilst when you file a request for unitary patent, you have this translation to be furnished and filed with the EPO. So depending on the countries, it will be cheaper or more expensive if you file a request for unitary effect. So if you want to, of course, if you want to get patent protection in all these 17 countries are listed here, you can imagine that all these translations, they are more expensive than just to have one translation in one language. What will also be cheaper are the renewal fees. So, but only in comparison to the coverage. So if you say, as you said, unitary patent will have now 17 countries, but it might cover 24 states. So this slide shows a comparison between the unitary patent and the potential territory coverage of the unitary patent in 24 member states. And here you can see that the renewal fees are less expensive for a unitary patent than for all 24 member states. This is always the argument which was brought forward in the past from the EPO and from all the parties who were in favor of a unitary patent system, because they said you can save so much money. If we look at such a fee table, we have then it might get a little different impression. So we have 4 columns: unitary patent plus United Kingdom, classic European patent. So what we do right now, just a validation in Germany, in France, and UK, or a classical European patent, so you validate it in Germany, France, UK, and in Italy. And if you compare these fees, then you have here for, if you cumulate everything, so sum up the first 10 years, you have here 4,600 euros for a unitary patent. If you additionally want coverage in UK, then you have 5,500. So this will be a unitary patent plus a national validation in United Kingdom. Then you have 5,500 euros. And if you just want to validate it as you do right now in Germany, France, and UK, at the end, you will only have renewal fees of 3,130 euros. If you validate it in Germany, France, UK, Italy, in the old way, as you do right now, or what you have done in the past, then the annual fees for these 4 countries sum up about 4,000 euros after 10 years. So it will even also be cheaper than the unitary patent. So as a rule of thumb is about, if you want to have 4 or more countries, then it might be cheaper at the long term to get a unitary patent. But if you want to just have protection in less than 4 countries, then I would recommend to do the old traditional way to validate it in country by country, because the fees are then lower. So this is all about the unitary patent. And so you have to really distinguish. The one is the unitary patent thing. This is just a new option, what you get after a European patent is granted for a selected number of countries. The Unified Patent Court is the new court system, which is also available from June 1st now. And I have already shown this slide before. So we have a first instance, a Court of Appeal instance, and then a revision instance before the Court of Justice of the European Union. Maybe a little bit shown, illustrated a little bit differently. So we have here lots of local or regional courts in these participating countries. And this is the first instance. We have a central division, which is in Paris and in Munich. And it was supposed to be also in London. We will just see on the next slide what happens there. Then we have a second instance. So if you are not happy with the first court decision, there will be a central appeal instance in Luxembourg. And if some questions of legal aspects are challenged by some parties, they can go to the European Court of Justice, which is the highest European court. So again, to the local, regional, and central divisions. Here on the right-hand side, you see a list of all the local divisions and regional divisions and the central division. Since in the past there was so many litigation, or most of the litigation cases were handled in Germany by German courts, Germany got 4 local divisions in what we have in the future, whilst other countries like here in Riga or Tallinn or Vilnius, they have so-called regional divisions. So they they will have only a very few, or in the past they only have a very low number of litigation cases, and therefore they collect or they will treat those cases together by a so-called regional division. And for some for some certain aspects, there is a central division. For example, if you file a action for revocation of a European patent, this will be handled by the central division of Paris. And there was some typical European negotiation. Everybody wanted to have the central division. Then it was said, oh, in Munich, you have already the European patent, and you have the German patent office. So the French said, oh, we want to have the central division. And there was a kind of a compromise between these countries, UK, France, and Munich, that the central division will be based in Paris, but some sections will be outsourced to a central division section in Munich, here in the mechanical engineering field in the IPC class F. And London was supposed to get the IPC classes A and C. As you know, London is now out because United Kingdom left the European Union, and since the system only deals with European Union member states, it can no longer be a host of a court of this system, and therefore right now we only have Paris and Munich. But there are some rumors, or also some proposals, that this section of the central division will be moved then to Milan in Italy. So therefore I have already here indicated Milan. It's very likely that they get the central division, which was supposed to be located in London. So what does the UPC in the future? So the UPC will handle infringement actions, patent infringement actions. If somebody files a revocation action against a patent, they will actions for declaration on non-infringement of a patent. Also, you get preliminary injunctions from the UPC, and some other there are some other tasks like compensation from the published patent application or some issues with the EPO. So the UPC will have the power to declare a European or a unitary patent invalid. It can order to cease and desist, destruction of infringing products, and the damages. So they can decide on the award of the damages to the injured party, and also preliminary injunction, as I said, freezing orders and sequestration. So where do you have to go when I have an infringer? I know there's some competitor. I have a European patent. So where do I have to litigate? And an action for infringement has to be filed with a local or regional division. And depending where actually the place where the infringement took place, so usually nowadays with internet and so on, usually you have always you have the choice between several countries where all this website is online. But if you have some infringement acts by sales, actual sales in one country, then you can go to that court or to that division which is responsible for this country. You can also file the action for infringement at the place of the defendant, and if the competitor does not have any principal place within those states, then you can file it with a central division. Also, the parties can agree that this case will be moved to the central division. Action for non-infringement will end up at the central division. Action for revocation. So if you want to attack a European patent, as you know, you have the option to file an opposition. So the opposition proceedings before the UPO will not change at all. It does not. So the opposition proceedings does not distinguish between unitary patents and classical EP patents. So opposition proceedings will still be centrally handled by the EPO. But once you missed the opposition, or the opposition, the result of the opposition was not as you liked, then you can file an action for revocation before the UPC or before a national court. And where to go, then we'll see later. But here we assume that the UPC is competent, and then you have to file it with the central division. So in Paris, and then it will be moved to, if it's an IPC class F case, then it will be moved to Munich, and A and C will be moved to possibly Milan, and all other IPC classes will be handled in Paris. What is now also possible in comparison to Germany? Germany, we have a bifurcation, so you have an action for infringement and in parallel an action for revocation. Once somebody has filed an action for infringement, he can also file a counterclaim for action of revocation. So you are sued and somebody files an action against you, and then you can defend yourself, that saying that, oh, this patent is not valid because I know prior art which questions the validity of this patent. So you can file an action for a counterclaim for revocation, and then when we have two questions to be answered, whether there is an infringement or not, and whether the patent is valid or not, and this might be handled by the local division or regional division where the infringement action was pending. And then there was usually there will be a technical member will be added. If it might also be the case that the division says, no, the question about whether the patent is valid or not, we will move this decision to the central division, and then we will stay the infringement action as long as this decision is made by the central division. And once the central division has made the decision regarding the validity of the patent, then they will continue on the level of the local or the regional division. Or the local and regional division may refer the case completely with both cases, with both questions, to the central division. Then action for infringement filed after action for revocation. So this is the other way around. This will also be, there are the same rules as we had before. Non-infringement, and then within 3 months infringement, then this action for declaration of non-infringement before the thing shall be stayed. And then we have some other. So upon parties agreement, you can go wherever you like. If it's some issue with the EPO, then this will be handled centrally with a central division. So of course, when you're not happy with this decision, you can go to the second instance, to the appeal court, but I don't want to go into detail for that. This is in the far future. So what is the territorial scope of such decisions of the UPC? And in case of a European patent with unitary effect, it will be the territory of the contracting member states in which the patent has unitary effect. So the UPC, if the UPC says, oh, this patent is valid or not, this will have effect for all 17 countries. And if they say there's an infringement or not, it will also have effect for this 17 countries. Right now, if you go before a German national court, they can only decide whether the German part of the European patent will be invalidated or not. And if the German court invalidates the German part of the European patent, all other national parts in France, UK, and so on, they will still continue. So therefore, this is when you want to attack a European patent, you have to go by country, and this is what makes it more complicated and time spending. And the same is for European patents. So this UPC will not only decide on unitary patents, but also on a European patent. So that it will also be able to the territory of the contracting states for which the European patent has taken effect. So language of the proceedings. There are lots of rules regarding the languages. Here is a slide where you see all these divisions from Austria up to Sweden, where they are based. This is what I already has shown before on one slide. So it will be in Vienna, Brussels, Stockholm, Helsinki, and so on. Here is the composition of the board. So depending on the number of cases for one countries, like here in Germany, we have a lot of litigation regarding European patents. So there will be 2 German judges and 1 judge from a pool. There will be judges from all over Europe. They are in a so-called pool, and whenever there's some case, 1 judge will be asked to join this board of the national judges. And in other countries, so like in Finland, they have not many cases. They will only have 1 national judge and 2 from these pools. Here are the languages, and this is quite interesting that most of the countries have allowed English. I actually all of them. So years ago, when this idea of the UPC was created, then everybody was afraid that, oh, now I will end up in Finland and I have to provide all documents in Finnish, and I have to speak, or I need translators from Finnish into English or whatever other language. So these concerns have not been realized. So you see, in most of these divisions, English will be accepted. So this is a good news for all the applicants or the patent owners, that they don't have to fear that they will end up at a court in Portugal or in Sweden, and they have to then talk in this national language. The proceedings before the court, there will be a written procedure, an interim procedure, an oral procedure, and regarding the damages after the decision, and regarding the costs. It will be a very tight schedule. So the idea from an action, from the filing of an action, an infringement action, until a decision, it should not take longer than 12 months. So 1 year. So this is very, very quick. We also in Germany, we also have courts which decide very, very, very quickly in the first instance. But in all over Europe, there are several court systems. You can imagine Italy, it takes ages to get a court decision. So until in instead of waiting to get a decision in Italy, a UPC is definitely faster. But if you have such a fast proceedings and with lots of interactions between the parties, it will require a very tight scheme and time management. So there must be quick reactions from all parties with respect to the time limits. So who is allowed to represent before the UPC? Of course, lawyers, they're usually always allowed to practice before a court. So if you have a lawyer authorized to practice before a court of a contracting status, then he's allowed to represent a company before the UPC. But usually a lawyer do not have the technical background of the cases to be discussed. Therefore, it's recommendable to engage a European patent attorney. But European patent attorneys are not automatically admitted to the UPC. So European patent attorneys need extra qualification, and this could be a bachelor or master degree in law. There will be a special course. I think, I don't know whether it has already started, but there will be a so-called European Patent Litigation certificate course. So you can attend such a course and then pass it, and then you are allowed to represent before the UPC. And or you have acquired additional appropriate qualifications. So there are some extra, also some other courses which existed in the past or still exist, which are also acknowledged as such qualifications. Or if you have represented a party in at least 3 patent infringement cases in the past 5 years, you have to prove that, and then you are also admitted. We as German patent attorneys, we are automatically admitted because the German patent attorney examination is quite sophisticated. So you have to always, before you pass or sit the patent attorney examination, we have to attend a law course at first, and this law course is considered to be such an appropriate qualification here listed here. Therefore, all German patent attorneys who also have passed the EQE, so this examination of the European Patent Office, or are admitted to the UPC. And this is for what the UPC again is competent. So according to this UPC agreement, the UPC will automatically be competent for European patents with unitary effect, for SPCs protected by a patent, then classical EP patents which have already been granted. So if you have patents which have been granted in the past, they will automatically be handled now by the UPC and no longer before a national court. The same is for European patents that will be filed or granted, or they are now pending and they will be granted after June 1st. And all applications, so European patent applications, they are pending or filed after the, all they will automatically be put in this new system. And so from June 1st, unless an action has already been brought before a national court, so there might be an exemption. One exemption is you have already some infringement case pending before a national court. Then such a case will not be will not be transferred to the UPC. So it will still be continued with a national court. But in future, all European patents will be handled by the UPC, except you file an opt-out. And this is what you may have heard about from your attorneys or some seminars or so on. Opt-out means that we just heard that all European patents, doesn't matter, unitary patent, classical EP patent, whether they have been granted in the past or will be granted in the future, they are automatically in the new system. And if you do not like that, you have to opt out your application, patent, or SPC from the exclusive competence of this new court. And this is possible during a 7 to 14 years transitional period. I think it will be just 7 years. There will be no extension, but in the agreement it is mentioned it can also be extended up to 14 years. But during such a period, so for the next 7 years, from now till 2030, you can opt out your application, patent, or SPC from the exclusive competence of the UPC, which means that your patent will still be handled by the classical court system in Germany, in UK, in France, which you are familiar with. But this opt-out is only possible for classic EP, so those that have been granted in the past. So there was no unitary patent in the past. So all already granted EP patents, they are classic EP patents. If you file in the future a request for unitary effect, so when you get a unitary patent, such a unitary patent, you cannot opt out. So a request for unitary effect results in a unitary patent, and such a unitary patent will automatically be handled by the UPC, and there's no way out to get a decision by a national court from such regarding your unitary patent. So you can now file such an opt-out request or application as just a precautionary measure. And this, look what happens, what are the first experience with this new court system. And if you think, oh, this new court system is not so bad as everybody says, then you can withdraw your opt-out declaration, and then you can opt in, or you get back to the new system. So what are the preconditions for such an opt-out request? Is the opt-out can only be made in respect of all states for which the European patent has been granted, which have been designated in the application. For example, your patent has been granted, and then you validate your patent in UK, in Germany, and in France. Then UK is out of the system anyway. Regarding the UK part, you have to go to the court before UK anyway. Regarding France and Germany, you can file an opt-out request that your validations in France and in Germany will be opted out, and in the future, if there's a litigation case or an action for revocation, this has to be brought before a court in France or in Germany, and the national court, as we do right now. Such an opt-out request is only possible as long as no action is pending in both directions. So if there's an action right now pending before the national court, it will stay with the national court. In the future, if it is already pending before the UPC, you cannot change the competence from the UPC to a national court. Once the action is filed, then you are bound to the UPC. Then all proprietors or applicants have to agree. So it's not possible if you have done a joint applicant or joint, so that you have two patent owners. So both have to agree on what to do, whether they want to stay in the system or whether they want to opt out. This application can only be made via this new software from the court, so the case management system, and this can be filed by anyone who is registered before the UPC or holds a mandate. So here again, in the lower level, you see if you file a request for unitary effect, then you have a unitary patent. You are automatically with a UPC and you cannot change it. So if you decide for a unitary effect, it will be dealt for a UPC. Now, for the classical European patent, which have been granted or will be granted, you can, if you do nothing, you will get automatically the competence of the UPC. And if you do not like to end up at the UPC, so you want to get your patent infringement case decided before national courts, because you have made good experience with that, then you can file an opt-out, and then you will get end up the national courts. So it's up to the proprietor, at least for the first 17 years, whether an action concerning the proprietor's European patent have to be brought before the UPC or the national court. So by this decision and by this decision, you can say what you want. So it's a patent proprietor's decision. Yeah. So here's a timeline. Right now, for example, if your European patent has already been granted in the past, you can now start to opt out here. We have a so-called sunrise period, which started last week. So it's already possible to opt out your patent, which have been granted in the past. Here's a case where your European patent will be granted in the future. So you can opt out. You have two options. You can opt out this case, this invention, still in the application phase. So as long as it is an application, or after grant of the patent. And this is possible. These opts out until so we have here the June 1st, which is the starting point. 7 years is 2030, and so the rule says it has to be made 1 month earlier. So May 1st is the deadline. So you can imagine that when you file still an EP application in 2030, you still have the option to opt it out, and so this has a lifetime up to 2050. So there will be a lot of EP applications still be handled before a national court in the future. But after 2030, it's no longer possible to opt out. And therefore, such EP applications filed in 2030 and later will be part of the UPC. And the only way to avoid the UPC in the future will be the national filings. So what are the to-dos right now? As I said, June 1st is the starting point of the Unitary Patent Court and the Unitary Patent System. From now, March 1st, it is possible to file such an opt-out application in order to make sure that on the very first day of the system, you will not get an invalidation action, and you have to then you can, that will be handled before the UPC for all countries. If you do not like that, you can file such an opt-out already right now. The EPO has also two transitional measures. So for applications, they are ready to grant. You can either file a request for delay to grant so that you can benefit for your patent from the new system, or already file a request for unitary effect. So here's this, what I said before. Now, June is a starting point. Here we have the sunrise period for the opt-out. Then we have a transitional period where you still can opt out. And from that time on, it's no longer possible to opt out. So all European patents will be handled then by the UPC, which is the basic idea. These are the two then I showed two examples of what the EPU now provides. So for example, we have a 71.3 communication here dispatched in January or last week or whatever. Then with the dispatch of the 71.3 communication, so this preliminary allowance, you can already file a request for unitary effect. You don't have to wait until it will be granted, or the grant of the patent will be published. For cases which have already been allowed, possibly end by last year, and then if you have these 4 months of the 71.3 communication, so it will be then possibly published here 1 month later. And then if it's published here, then you have, and you want to have a unitary patent, then it will be too early. So once you have a 71.3 communication, now you can file a request for delay of the publication. So until the system starts, then you get a publication of the measure. And then you have 1 month to file such a unitary effect. So if you wanna, if you have a patent which has been granted recently, this is quite good information that there is the possibility to delay the grant or the publication of the grant, which is decisive for whether or not you can file a request for unitary effect. So what are the pros and cons? Of course, for the unitary patent first, positives definitely that you have a central administration for 17 states. So you have a one-stop shop at the EPO. As you know, right now, you have to validate it in country by country. And then later on, you also have to deal with different attorneys or different offices. So this makes it quite complicated, and some also have different rules, and then they have also different currencies. Now in the European Union, not, but in some other countries which are but not part of the system. Anyway, but it makes it complicated. If you, it's nice to have just a one-stop shop at the EPO. There will be no official fees for this unitary effect. You also don't need a representative. This is also good news for, not for us, but for you as possible applicant. You have only a cost for one full translation instead of several translations. The renewal fees are lower if the EP would be validated in 4 or more out of the 17 countries. And you have one register, which is also quite transparent. So you don't have to check whether this patent is still valid in Italy or in Greece or wherever. So you have one register. What are the cons? Most of them applicants or patent proprietors are interested in the market of UK. Also for you from South America, Spain is probably also of importance. Portugal is in, but Spain is out. So some markets, or Switzerland, Turkey, which are also of importance, are not part of the system. So it would be more beneficial if more countries would take part. But the European, it is linked to the European Union, and even within the European Union, not all countries take part right now. Another problem is the risk of central revocation. So by a single attack, your European patent or your unitary patent can be validated by one decision from the UPC, which is not the case right now. So you have this central attack. So in particular, companies from the pharmaceutical field, they have patents all over Europe. I think those will probably opt out to benefit from many national decisions and not just from one decision made by the UPC. So what is then we have the exclusive competence of the UPC. There's a new court. You don't know how it works, how they will decide. We have no case law right now. The procedure is still not clear. And it must be licensed or transferred, abandoned as a single right. That means you can, once you have a unitary patent, you cannot say you just drop France and you only want to have Germany left. So you have all one nothing. So you have to pay for the unitary patent, the next renewal fee, or you have to drop it entirely. Also, you cannot license it just for you want to license it in France to party A and in Germany to party B. This is also not possible with a unitary patent. Then it was also possible that a national prior art in one state invalidates your entire unitary patent. If you have not such a unitary patent, such a prior art would only be relevant for such one country. So all other could continue to exist, but such a national prior art might invalidate your unitary patent entirely. And the translation cost might be higher if you, in comparison to a validation in France, Germany, Netherlands, UK, because all those are parties of the London agreements, and they have waived with an obligation for translations. So you don't have to file a translation at all. So such countries might be cheaper in the traditional way than in the unitary patent. So unified patent court, what are the pros? You have a single proceedings, one language, one decision. So you always have these two that might be positive or it might be negative, but for practitioners, definitely this is positive. Then you get decisions with remedies for all 17 EPC states. So you don't have to, when you have kind of an order to cease and desist, it will be valid for all 17 countries and not just for one country if you have just a national court decision. And the first instance decision will be quicker than in most countries right now. What are the cons? We have a new court, new rules, no existing case law, so nobody knows how it really works. So it will be kind of an experiment, but I think I have confidence that it will work, but nevertheless, it's something new. The risk of central co-revocation, which I already said. We have short deadlines in the procedure, which requires capacity also in your in the offices, and it might be the UPC courts they might be more expensive than a single national litigation proceeding. So usually you have, when you litigate a patent in Europe, you will not file parallel litigation cases all over Europe. You start, or most parties start a litigation case in Germany because it's cheap in terms of court fees and so on. And this is used as a pilot case, and depending on the outcome, you will start negotiating or settle the case for the rest of Europe. This is what usually is done. So personal remarks, classical EP or unitary patent. So first of all, of course, you get a big package, but the question is whether you really need patent protection in all of these countries. on the right side, I have shown you some statistics. So on the right side is the ranking of the 39 countries among the EPC. So we have a lot of countries like Latvia, Lithuania, and so on, Malta, being part of this unitary patent, but they have rather low importance. Of course, Germany is part of it, France is part of it, Belgium is part of it, Italy is part of it. So these are important markets, but all the rest you basically don't in most cases you don't need. So I would recommend to select first the member states and then to compare what is more reasonable to request a unitary patent or go do the old way. If you want to have it flexible in terms of licensing, transfer, or abandonment, then classical EP would be recommendable, because then you can drop in different years, different, so you don't have to continue for certain countries. You just continue keeping one patent alive, for example, in Germany or in France. Is your patent of particular importance? Then, of course, the recommendation is don't put all eggs into one basket. So pharmaceutical patents probably will not risk it to make this patent accessible to a one decision from the UPC. On the other hand, if you just want to get most for little money, it's not little money, but it's better than if you would have to validate in country by country, then you go for a unitary patent. Opt out, opt in. From a perspective of a defendant, also if you are, unfortunately, it does not show all data here. So from the perspective of a defendant, so now everybody says, oh, you have to opt out now. There's a sunrise period. Everybody has to opt out now, because on June 1st, everybody will attack your patent, and if it's not opt out, then it will be invalidated by the UPC. So it is not the case that normally no European patent is attacked just for fun. So it's very seldom that a European patent is attacked without any prior disputes, correspondence, possibly opposition proceedings. So in general, it doesn't matter whether you have to opt out it or not. From the perspective of a plaintiff, so if you are the owner and you want to enforce your patent, then it's up to you when to file the action for infringement. And if you want to bring it before the UPC, then you just file the action for litigation with a UPC. And if you want to have it handled before the national court, then you still can file an opt-out application and file it with the national court after that. So you don't have to rush. Here there was some box. I don't know why it is no longer part. Here it said, don't panic right now. So keep cool and don't follow the recommendations of many law firms now in Europe. Oh, you have to opt out and spend a lot of money for this opt-out procedure, because the attorneys charge money for that, or the official fee is nothing, but the handling fee is it's some work to file such an opt-out request. Therefore, the offices charge you some fees for each opt-out request. So we only some of our clients have so far decided to opt out. So the majority stays with the system. So that was a a huge ride through the UPC in the unitary patent. So I hope we have still some time left for questions and answers. Thank you very much.
Thank you, Mikhail. It was great. Yes, very clear presentation. Yes, we have 5 minutes or 7 minutes if there is any questions or if there's any doubt. For me, I at the beginning when I was studying these these modifications, I have some questions, but now you have answered them completely. So I do not have questions. If anyone would like to ask something, you can use the chat or the question and answer box.
And probably you can also ask a question in Portuguese,
Yes.
and I can understand it also. Yeah.
No, I think, well, I think we do not have questions, so we can end in time. So thank you again, Mikhail. It was really clear and very specific presentation. So we see if we can repeat in the future. If you are available, we talk it later. So thank you very much for your time and for the material and the explanation. That was very, very interesting. It was a pleasure.
So, yeah. So I have provided you with a slide. So it's fine with me if you share this presentation with attendees.
Mm-hmm.
So and if there are any questions, you have my contacts then, and just write an email, and I would be happy to answer those questions.
Oh, thank you. So we are going to. Oh, there's a. Okay, Giovanna, she would like to read the presentation. So we are going to share the material with the presented here. So thank you very much.
Yes, I'm happy to share it. So and yeah, when you decide to opt out anytime, we have already kind of an application which facilitates such an opt-out request in a bulk system. So we can make multiple opt-out requests at once with this software application, and so it would be not so not such a big problem. And we can also do it for applicants or patent owners which you are not right representing.
Okay, I think, thank you again. I think we can end this. Então, obrigada a todos pela presença até aqui. Espero que tenham gostado. Nós vamos circular a apresentação entre os participantes e qualquer dúvida, ela tem os contatos do Mikhail. Vocês podem entrar em contato direto com ele ou conosco aqui no Veirano. Fiquem à vontade. Então, mais uma vez, obrigada a todos e até a próxima. Thank you, Mikhail.
We have now one question regarding pharmaceutical patents. So this is my.
Sorry, so, Alexandre, I didn't see, eu não vi sua pergunta. Desculpa.
It came in just right now. So I'm a mechanical engineer, so I'm not really familiar with a pharmaceutical patents. But as far as I have heard from pharmaceutical companies, they usually have a lot of money to make it hard for everybody who wants to attack their patent. So they prefer to spend money in the translation and so on, and to validate it country by country and to stay out of the system, because it makes it more difficult for competitors to remove patent protection if they have to attack it in every country, because as I said before, if you can invalidate a patent, or at least restrict the patent claim in one country, it does not necessarily mean that a court in another country comes to the same conclusion. So you might get different decisions from different courts in different countries. So at the end, you might be happy if it's not invalidated, but it's at least well, it is just restricted in one country, and you can still make money or keep competitors out of one country, and you don't lose your patent all over these 17 countries. But yeah, usually pharmaceutical patents are handled like all others. I think the EPO is generally quite strict with the granting of the patents, but yeah, I do not know any particular differences with respect to pharmaceutical patents. But if you have one specific question, please write me an email. I will be happy to forward it to my colleagues from the pharmaceutical department. They will be happy to answer it. Thank you very much.
Obrigada, Alexandre, pela pergunta. Obrigada, Micael. Bom, pessoal, então eu vou encerrar. A gente encerra hoje. Muito obrigada pela presença mais uma vez e até a próxima. Obrigada, Micael.
Obrigada. Então,